Welcome to ICARE's Litigating and Legislating for Animal Rights Seminar Series. So glad to see all of you joining us from around the world for this fourth seminar, where we continue to explore how law can become an effective instrument for recognizing and enforcing the rights of animals. For those of you who don't know me, I'm Ana Albert, and I'm an interdisciplinary legal scholar from São Paulo, Brazil. And I'm truly honored to be the moderator of this seminar. And I'm looking forward to our conversation today, which is centered on the right to rescue and voluntary prosecution in animal advocacy, where we will examine how these strategies are emerging in real world litigation and advocacy, the opportunities they present for systemic change, and the legal, philosophical, and practical risks they entail. So without further ado, I'm very excited to welcome our guest for today, Professor Matthew Liebman, Professor Justin Marceau, and activist and animal rights lawyer Wayne Husing. Thank you so much for being with us here today. Maybe you could start by introducing yourself to the audience and then telling us a little bit about your work.
Hi, everyone. I'm Matthew Liebman. I am the chair of the Justice for Animals program at the University of San Francisco School of Law. I've been teaching at USF since 2020, and I teach 3 different animal law courses. I also teach torts and professional responsibility, and my scholarship focuses on social movement lawyering and fundamental legal rights for animals. Before I came to USF, I was a litigator. I was the director of litigation at the Animal Legal Defense Fund for 3 years. And before that, was a staff attorney at ALDF for about 9 years, doing a variety of animal protection cases, primarily civil litigation. It's great to be here.
Hi, I'm Justin.
Go on.
Delighted to join, really happy to be here. Like Matthew, I'm a law professor. Matthew didn't mention that he just won the most prestigious legal ethics award for a paper that he wrote about representing animals. So, I'll just do his bio for him too. But no, I'm really happy to be here and be part of this. I'm a law professor in Colorado at the University of Denver. I direct our animal law program and also an activist defense project. I, have written a lot of articles and some books. But really, the 2 things that I'm most proud of having done involve both of the people on this panel, and that was just fortuitous. So thank you to ICARE for such a good panel. I mean, one of them was with Matthew. We spent several years together litigating ag gag cases, sort of arguing for transparency in factory farming across the U.S. And then along with Wayne, through conversations and being inspired by the work that he's doing in activism and open rescue, started this activist defense project to sort of litigate around issues of rescuing animals and defending activists. So thank you so much.
Thank you, Justin. Wayne.
I'm Wayne, and I have no idea why I'm on this panel. I have these incredibly distinguished professors and legal scholars talking to me about these subjects, and sometimes I'm honestly a little befuddled as to why, because 20 years ago when I tried to become a legal academic, I failed miserably. 10 years ago when I started doing this work, almost every lawyer who talked to me about this said I was out of my mind. I had a conversation with Ingrid Newkirk, who actually begged me not to do this work because she actually thought highly of me. She just didn't want me to throw my life away. But what I've done mostly over the last 10 to 15 years is a strategy called open rescue. And much to my surprise, 20 years ago, and maybe even 10 years ago, but not today, the strategy has been extraordinarily successful. And there have been some sacrifices, some people, including my friend Zoe, who's going to jail today, who have borne the brunt of that strategy. But I nonetheless think it is one of the most compelling strategies, not just for litigation, but for the fight for animal rights. And excited to talk about it.
Thank you, Wayne. Thank you for being here. The 3 of you are so impressive, and we are so honored to have you guys here to discuss this very important issue, right? So let's start our conversation. Our seminar today refers to the right to rescue and voluntary prosecution in animal advocacy. So for those who may not be familiar with these terms, Matthew, could you please start by defining the right to rescue within the broader landscape of animal law and advocacy?
Sure, yeah, and I'll invite Wayne to correct me when I'm done because I believe he's the person that coined the term. So I'll sort of give my outsider's perspective and understanding, which is that the right to rescue, as the name suggests, is the right of individuals, primarily those who are not affiliated with government institutions or organizations, not police officers, not agency representatives, the right of everyday individuals to intervene, to rescue animals who are in harm's way, particularly those who are victims of animal cruelty, criminal animal cruelty. And I think it's important to think about the right to rescue really in kind of three different registers, each of which I think has its importance. The first is descriptive. So what is the law right now? Is there actually in positive law a right to rescue animals? And I think the work that's being done suggests that there are many instances in which there are. So things like the right to rescue dogs in hot cars, clearly established under many state laws. And so descriptively, there is such a thing as the right to rescue. What its parameters are, how far does it go, I think is definitely open for debate. But there's a descriptive component there. The second register is the normative, which is the idea that there should be something like a right to rescue. If we're thinking ethically, is there the right to intervene to help animals who are suffering? And with that is kind of all of the moral, ethical questions wrapped up in who animals are, what their legal entitlements should be, and so on. And then the third is what's called prefigurative. And this is something I'm working on with Iselin Gambert and Elon Abrel. And this idea of prefiguration is sort of mediating what is with what should be and sort of actualizing the vision that we have of a multi-species future in the here and now. And I think the right to rescue does that as well. And even if there is not in the current moment such a thing as the right to rescue animals, the act of doing it and forcing the issue before the courts is a way of in some ways living the future that we want to see in decades time. So I'll stop there, but that I think is how I conceptualize the right to rescue. Maybe I'll invite Wayne to correct anything I might have misstated.
Brilliant. Wayne, would you like to jump in?
No, I think it was beautifully stated. The one thing I'd say is we actually kind of stole this concept from right to rescue bills already being passed across the country for dogs and cats. And we just said, well, if we can rescue a dog from a hot car, why not a chicken from a slaughterhouse?
Perfect. That makes complete sense. Yeah. So building on my previous question, Justin, how would you define voluntary prosecution and what do animal activists and their lawyers usually hope to achieve by using this strategy?
Yeah, it's a great question. I mean, there's a lot of pieces to it. Again, oddly, I mean, this is why it's strange for Wayne to say why is he in this meeting. I mean, credit where credit is due. I mean, Wayne coined this phrase, so I think it's a brilliant phrase. But maybe Wayne will disagree. You should jump in, Wayne. I think I did more of the drafting of the article because he happened to be incarcerated, but he did come up with the title, which is brilliant. But what we mean by voluntary prosecution, and of course, I'm interested in how others would conceptualize this, is basically the idea of activists intentionally putting themselves in situations where criminal prosecution is likely. And I mean, sit with that for a second, because it's a very strange use of the law. Why would someone possibly pursue or court criminal charges? Why would that happen? And speaking only from the American context, it's not because we think that the criminal system is fair or that it is some beacon of truth. It's because we think of the criminal courtroom in particular as a venue that can be a very powerful public platform for talking about what's going on inside of animal exploiting industries like factory farms, right? It's a very powerful stage in that way. It's very hard to get sustained public attention to the legal failures of animals. That's kind of the concept that we were wrestling with when we were working on this paper. And the criminal system and the criminal trial in particular has all of its formality and all of its, sort of public appeal. It's got media interest, it's got witnesses under oath, it's got all these fancy things like, subpoenas and the like. And the narrative structure just gives this formality to something that allows for a really clear telling about what's happening in factory farms, right? So to give just a really concrete example, even as a law professor, when I tell people that the law regarding the protection of animals is just woefully inadequate, that the law is doing more harm than good in many ways, people engage for a little while. Like they want to hear, they're a little curious, but eventually it seems kind of technocratic and their eyes glaze over, even law students. Or maybe they think I'm exaggerating because I like animals and I happen to be vegan. But that's not the way that it plays out when someone like Wayne rescues a couple of animals who are laying in a pile or are diseased and sick and need urgent medical care, right? When you give that script and you're able to, over a sustained period of time, tell that legal story that Wayne is the one who's treated as the bad guy, that Wayne is the one who's prosecuted, and that the factory farm is not facing charges. There's something about that legal setup that is really powerful. And I think it's intuitive. It's intuitive to an elementary school student. It's intuitive to a law student. It's intuitive to a general member of the public, right? The injustice that is happening on factory farms because of the law becomes more visceral. It becomes more visible. And I think that's what voluntary prosecution is for me. It's using the law to think about ways to put animal exploitation at the large scale that's otherwise invisible, kind of front and center, and using legal mechanisms to do so.
Brilliant, Justin. Wayne, would you like to jump in?
Yeah, I'll just say two things to put some flesh on the vegan bone there. One is, if you look at kind of what's unfolded over the last 10 to 20 years in animal rights, so much of the attention generated by the animal rights movement has been generated by various legal prosecutions, efforts to silence or censor activists. I mean, the ag-gag law stuff that Matthew and Justin did was just incredibly powerful for the animal rights movement. One of the greatest mistakes the animal ag industry made was trying to silence us and putting us in jail for taking photographs. But if you look at Zoe's trial, all of us have probably struggled to get our family members or friends. If you're part of an organization, you're probably struggling to get the media to pay any attention to animal rights. No one cares. Zoe's case alone has generated over 200 million views on social media and a dozen or so articles in the largest publications in the world. That is a source of power, attention alone. But the second thing I want to say is attention obviously isn't enough. We also have to get people to side with us to make decisions in a way that's favorable for animals. And I think one of the beauties of these prosecutions is that at the end of the day, it's not some elite stakeholder, some corporate executive, or some judge even, who's going to decide whether to side with animal rights. We finally get a chance to talk to the public. And at least in systems like the United States, we get to argue a case before a jury. Turns out we often win.
Very good. Yeah, you guys are telling the story under a different light. That's a brilliant strategy. So my next question is actually to you, Wayne. So now that we have discussed and clarified what the right to rescue and voluntary prosecution mean, maybe you could define for us the more specific practice of open rescue. And then can you also explain how all of these different strategies can be combined in the same trial?
Yeah, open rescue is just, in so many ways, such a fascinating and nuanced and sophisticated subject because it relates to this long history, not just in animal rights, but just in social justice causes of what direct action means. I mean, the classic definition of direct action is just being the change you want to see in the world, not waiting for the institutions and systems around you to do the right thing, just making sure justice is brought into the world with your own hands, your own feet, your own body. And open rescue is definitely that. That's part of the reason people do this, because we're tired of seeing these animals being abused. We're just going to take them out. It's a very direct and simple solution. But there's a second layer to direct action, obviously, which is its symbolic importance. And Matthew referenced this as prefigurative politics. That part of what we're trying to do is bring into alignment what the legal system currently says and what the legal system ought to say, the way the world ought to be. And I think that's partly a legal question, but what the theory behind open rescue is more importantly just a cultural. It's a political question. It's a narrative question about who we are as a species, who we are as a civilization. And when Patty Mark first launched this movement in the 1880s and 1990s, and for those of you who don't know Patty Mark, please Google her, learn her story. It's just tremendous that this grandmother in Australia decided to take things in her own hands, but also had the sophistication and wisdom to understand that doing this under cover of night, and I no shade on the ALF activists. I think the ALF has been tremendously powerful. It's done a lot of really great things in the United States and around the world. But the genius that Patty had, the conviction, the faith that Patty had is, we can do this openly. Because if we actually just show people what's happening to these animals and why we decided to take direct action, they're going to be on our side. And that was a bet. That was a very dangerous bet in the 1980s and 1990s. I mean, it's still to a certain extent a dangerous bet today, but we can talk about why I think it's a much less dangerous bet today in 2025. Part of the reason for that is, I've served the longest sentence in the history of open rescue in the United States. I served 37 days. Zoe Rosenberg is about to go into jail today, and it's an awful verdict. I hate it. I'm worried about her and her family, and I've talked to her mom, and her mom is in tears about how scared she is. At the same time, she's going to be in jail for 14 days, right? Part of the reason for that is because even those who try to undermine our arguments, undermine the very people advocating for animals, recognize something powerful, which is that when someone is trying to give aid to an animal, even if they're technically breaking the law, even if they're disrupting powerful people and powerful systems, on some level, we have to kind of sympathize with them. And so I think the fight that Open Rescue is trying to fight is as much about the court of public opinion, about the court of law. So you also asked how to integrate all these three things. I think that the legislative and normative angle of the right to rescue is, in many ways, it is the apotheosis of open rescue, the distillation of what open rescue is supposed to be about. Because it's really not just about getting this one animal out or getting out of jail free for me personally. It's about normalizing this idea that our entire society should be rescuing animals. And the mechanism through which we achieve that goal, that apotheosis, is voluntary prosecution. That one of the ways you get to that destination is you put your money where your mouth is by going on trial. And, Patty started doing in the 1990s. She inspired so many people across the entire world, including me. And now Zoe Rosenberg is putting her own freedom on the line. And I hope it inspires someone else, whether it's a lawyer, someone who wants to donate a few dollars to her legal defense, or an activist who wants to follow in her footsteps and walk into a slaughterhouse and take an animal out. That is the fight, the flywheel effect, culturally, politically, and even in terms of our own bodies and hands and feet, that we're trying to create. Momentum for change that ends with a right to rescue every single animal from every slaughterhouse across the world.
Perfect. Thank you so much for that. So, Justin, could you please elaborate on how voluntary prosecution has been used by other liberation movements and maybe give examples? And how does it differ from other strategies like civil disobedience or jury nullification? And why does this difference matter, specifically in the context of animal rescue cases?
Yeah, I mean, I'll say briefly. I mean, I'd be interested in. I mean, I think there's probably lots of examples that other panelists or even people in the audience could draw upon, and I'd be interested to learn. I mean, it's something that I've thought about as a longer term research project. I mean, we talk about a couple of examples, including women's suffrage, the LGBT movement, but there's really lots of them. I mean, the idea of having the ability, I mean, this is a key question, right? Like, who has the privilege, who has the ability, who has the courage and the willingness to face prosecution, right? And I would say, I mean, in some ways, right, the having charges, felony charges in a state like California, right? The prosecutors are charging felonies for conspiring to commit misdemeanors, right? I mean, that's an unbelievable thing. But to having that hang over your head for months or years is an extremely challenging thing. And so there's a certain type of person who has to be open to that, and they have to go in with their eyes wide open, right? I mean, I think you have to. I mean, that's something that we haven't touched on yet. It's just like this is not a kind of play acting or some sort of thing where you say, "Hey, I'll do this," and maybe a decade ago, Wayne could talk to that history and say, like, I don't think anything is going to happen. Like, the consequences and the stakes are real, and so I just want to be clear about that. But people facing that kind of risk have stood up throughout history, and it's been profoundly important, right? I mean, you could imagine that happening now in contexts where people are blowing whistles about ICE and the other thing. I mean, we could talk about and they want that prosecution. They want a prosecution for saying, look, I didn't want the preschool teacher in my school to be arrested. And so I blew a whistle. Does that make them an accomplice to, unlawful immigration offenses in the U.S.? I mean, we could debate that question, but there's a sort of a propensity to say this is so absurd that the law has it so wrong that I am willing to be a part of the system that shows that wrongness and how you make legal change. And so, an example that we talk about that I think is robust and often forgotten in U.S. history is just the ability of women to vote. Right? They thought they had a legal hook to do so, and people like Susan B. Anthony, who've been historically maligned and partially fairly so on other lines of thought, including insensitivity to racial injustice. She was an absolute warrior when it came to saying, I believe that the 14th Amendment in the US says that all people have a right to vote, because that's what the text says. And I believe that as a woman, I should be able to vote. And she was getting some legal opinions that said yes. And the clerks and the voting officials said, no, you can't vote. And she showed up and just said, give me a ballot and voted, right? And she was told that she was going to be prosecuted if she did that. And then she was offered various, off ramps to avoid prosecution, but she wanted the trial. She wanted the spectacle. She wanted to make it clear that the idea that in the 20th century, women ought not be able to vote was just an absurdity. And so she was willing to face prosecution for that. And there's other legendary folks who did this across movements. But like I said, you don't even have to think of it in a large organized women's suffragist movement. You could think of it in terms of just a law that is grossly affecting a movement. Like, is there something about drug crimes that is really offensive? Like, is a needle exchange site, is a testing center, the operation of it, is it so offensive that it requires prosecution? What about a person who's running a testing center in order to avoid constant fentanyl overdoses in his neighborhood? If he does that and he's prosecuted, he may court that prosecution to make a message, right? Now, is that good? Is it bad? We can have normative conversations about that. But the point that we're trying to make is that there is a function in the law that is extra legal, that you can do things by using the law, and the law will eventually bend to that. Like the prosecutor feels uncomfortable, and the public has to have a reaction to the prosecution of that person. So, I mean, we could go on and on, but like I said, my panelists probably have more interesting examples, and I bet people in the audience from across the world could speculate about times when they've thought that the prosecution here is going to be important. And I'll just end that answer because it's such an interesting question by saying this builds on a large social science literature about backlash and backfiring effects, right? What we're really trying to illustrate is that sometimes you have to have overreach by the state, and it's a calculation that when they overreach and they overplay their hand, that's how you're going to gain momentum. It's not just by litigating cases around the margins and hoping you pick off small victories. It's by showing that their position is so bad that when they sort of reach out and oppress someone, that's what's going to trigger public momentum and public sentiment, right? So police reacting to a protest is more powerful perhaps than the protest. Prosecutors bringing charges against Wayne and Zoe is perhaps more powerful than the acts themselves underlying the prosecution.
Perfect. That's great. Thank you, Justin. My next question is also directed at you. So you've written very critically about carceral logics in animal protection. How do you navigate the tension between, on the one hand, opposing over criminalization and punitive systems, and on the other, strategically embracing criminal trials through voluntary prosecution? Also, in terms of the outcome expected, how is voluntary prosecution different from prosecuting corporations or industries that harm animals directly?
Those are great questions. Thank you. Yeah, I could say a lot about that. I'll answer the first one, the bigger one, very briefly, and happy to say more about it in Q&A. And then I'll say a couple more words about the secondary question. I mean, for me, yes, I am extremely critical of prosecution of individuals, and I think that it is itself having a backfiring effect against the animal movement. And I have some empirical work that I've done that tends to show that. But basically, I don't disagree with the idea that the criminal law can be an important expressive message sender, right? That the expressive function of the law is powerful through the criminal law. I just think the message we are sending when we prosecute individuals is the wrong message. It's a distracting message. It's a message that we are taking care of things by handling it through little individuals who have hurt their dog or their cat or one-off animals. The power of the expressive function of the criminal law, though, it is not something that I deny. And so what we're trying to do is harness the expressive power just through the defense of activists and the illustration of how bad the system can be, not by saying, oh, well, if we put this person in jail, people are going to learn that animals matter. Now, your other question, that was the small one, I think is really interesting. Like, how does it differ from corporate prosecution? And I have to say, I haven't thought about that a ton, but I like both. But I think my basic answer is that one of the insights of voluntary prosecution is that activists are trying to leverage the real world practical practice experience knowledge that prosecutors tend to be deeply biased in favor of the status quo and deeply biased in favor of corporate power and prosecution, and corporations and animal industries. So when an animal activist pushes for a prosecution of a factory farm or a puppy mill or corporate facility, they will quickly hear prosecutors retreat to the well-worn talking points of a high burden of proof, limited resources, not sure if they have the right authority or the power. We ought to leave this to the regulators. This looks like a civil matter that could be regulated. All of these excuses, right? I mean, probably everyone in this has heard some version of that when they have tried to have a powerful entity prosecuted. But when you look at the prosecution that people like Zoe and Wayne and these other activists, it's exactly the opposite script, right? When prosecutors go after animal activists, we discover wildly expansive theories of criminal law that we've never seen. Wayne is an accomplice for giving a speech across the street from a factory farm. I mean, that's a theory of accomplice liability. He was an aider and abetter from standing across the street talking about the lives of animals. Aggressive charging decisions, and a remarkable confidence that the jury is going to convict and that it's fully ethical to prosecute, right? I mean, that juxtaposition is really the reason that we see voluntary prosecution. And what I am trying to leverage through voluntary prosecution in our clinic is the idea that we could flip that asymmetry into an opportunity, right? If prosecutors are really going to treat activists as criminals and give corporations a pass, then what are we going to do? Then we still have to look for options in the law. Then activist defense gives the opportunity to drag factory farms into the courtroom anyway, right? Maybe as witnesses, maybe to talk about what they're doing, maybe to defend their practices, maybe to say how different it is than a hot car. This is not at all like a hot car. We only have 5,000 chickens and no ventilation, right? This isn't a hot car at all. I mean, these are the types of legal questions that we want to put before the public, right? Dogs in such small conditions that we could possibly, not even possibly imagine the amount of suffering that's going on, and have the prosecutor confront that reality and say, well, what are you going to do, right? Are you going to prosecute activists? You're going to prosecute the corporation. So that's a long answer, but I hope that's helpful.
No, but that was very interesting. Thank you. So my next question is to Matthew. So Matthew, even if activists do not win in court, how significant could the social impact of their actions be for society? So these activists rescue animals and face criminal charges for attempting to change how farmed animals or animals used in research are exploited and treated. Do you think these acts of civil disobedience can help expose the violence at the core of animal agriculture and experimentation and accelerate broader legal and ethical change even in the face of conviction?
Yeah, I do. And I think Wayne and Justin have already touched on this a bit, that if we're thinking about, legal actions, legal prosecutions, even civil litigation, these are not sort of confined to the judicial sphere. These don't only take place on that plane. They also operate in a social and cultural and, as Wayne says, narrative scope as well. And so, one could have success in one domain and fail in another. And so there's actually a fair amount of scholarly literature on this question about social movements. There's a article by a Yale professor named Doug Najim called Winning Through Losing, that addresses this precise question, that sometimes you might lose in court, but there are benefits to be gained from losing in court. And those, I think we could identify examples of each of those in the right to rescue context. So one of them that he gives is mobilization. So there could be increased social movement mobilization as a result of losses. Generally, we think of wins as being galvanizing, but the same is true of losses. So if there's a conviction that spurs outrage within the movement community, as Wayne says, Zoe's case can inspire others to do the same, notwithstanding the fact that she was in fact convicted. So mobilization is one. Consciousness raising is another. I think as we've been, hundreds of news articles about Zoe's case that make this issue reach other folks as well, and creates conversations around this. I've mentioned in my, as I said, I teach torts. I've got 50 first-year students, a couple of whom are interested in animal law, but most of them don't care. But when I mention, when we're talking about the necessity defense in tort law, I brought up this case, and people were astonished that someone was facing up to 5 years in prison for rescuing 4 chickens from a slaughterhouse. A third metric of success could be the way that it frames grievances. And that is, the right to rescue, I think, is really recasting what this act of rescue is, drawing those analogies to other animals that we already care about. And then a fourth metric of success in winning through losing would be legislative reform. So that can be something that's driven by that public reaction. It's not just sort of we're angry about this, but it can channel that into other forms of legal reform. And I know DXE has capitalized on the various prosecutions to push municipalities to pass resolutions about the right to rescue. And I think there's a lot more that could be done on that front in codifying a right to rescue. So I think this idea of winning through losing is a really important one. Now, I should note, Najim just released another article saying, when I said that you can win by losing, that doesn't mean every time you lose, you're also winning at the same time. We have to be really thoughtful and considerate about this. It's not an excuse to be careless or reckless or to file cases that we know we're going to lose and might lose badly. As Wayne says, you can lose by losing too. So I do think all of this has to continue to be a thoughtful, strategic process where we're kind of weighing what are the odds of mobilization. Are we going to raise the public consciousness? Are we going to, will this be able to cash out in legislative wins, and so on. But I think, once we sort of stop thinking about things in a strictly, within the walls of the courthouse and start thinking about them in a sort of social sense, there's a lot to be said for winning through losing.
Thank you, Matthew. Wayne jumped in with that great comment. So my next question is actually directed at you, Wayne. So on that note of losing through losing, what are some of the risks of using criminal trials as advocacy platforms? Could these strategies unintentionally reinforce punitive or anthropocentric frameworks? That is, could voluntary prosecution backfire by normalizing harsh charges or generating bad precedents?
Yeah, this is This is an argument I hear from a lot of lawyers, and I have to say that the pearl clutching from lawyers about bad precedent is one of the biggest obstacles for the animal rights movement. Let me tell you some examples of people who decided to go on trial, lost, and still had tremendous impacts. Socrates, Jesus Christ, Susan B. Anthony, obviously Rosa Parks. Everybody knows her name. No one knows she was convicted. And it's not just Rosa Parks. Martin Luther King Jr. was convicted repeatedly. Ralph Abernathy took a case, lost to the Alabama Supreme Court, and won at the U.S. Supreme Court, but many years later. And I think there's something about the profession of the law that doesn't just teach people who are in the law what the law is, but normalizes the idea that you have to respect the law, and anything that the law says against us is now this huge crisis, because this is typically what happens in a courtroom. And if you do something that breaks the rules in any small way, you get lectured. And I think the legal side of the animal rights movement around the world has normalized that way too much, that sometimes it's okay to even have a bad precedent, because bad precedents, I mean, there's some pretty bad precedents in the history of social justice, Plessy versus Ferguson, right? The idea that we should be so afraid of a legal decision maker, even a very powerful legal decision maker, siding against us is one of the biggest obstacles to engaging in bolder and more effective action. Having said that, I agree completely with what Matthew said about the strategic calculus. If a concern isn't just about your reputation in the courtroom and about, this weird tone policing that lawyers engage in with grassroots activists all the time, that you've got to be normal, you've got to be upright, you've got to follow the law, then I think it's a thoughtful conversation. And I think strategic movements have done this, right? So the civil rights movement, Rosa Parks decided to ignore what a lot of the lawyers said and just decided, let's just take this case to trial. That was actually part of a strategic calculus by the civil rights movement. Just a few months prior, there was another woman named Claudette Colvin who was in a very similar case, and the NAACP decided not to pursue that case, partly because she was an unwed mother. She got pregnant. And by our standards, that's in many ways messed up, and maybe they should have pursued the case, and maybe it was a reflection of some deep injustice within the movement that they didn't pursue the case. But nonetheless, that shows you there was strategic thinking. They didn't just decide, let's lose every case. They decided, let's find the cases that even if we lose, a case like Rosa Parks, who's, for various reasons a good defendant, even if we lose the actual criminal trial, we can win in the court of public opinion. That's exactly what happened. So I think these consequences can be avoided, but this idea that we have to avoid any sort of bad precedent, I actually tried a couple years ago to look at how much bad precedents have stopped social movements, and I could find very little evidence that any bad precedents have had much of an effect on social movements. They certainly had bad effects on lawyers, but there's a certain narcissism that is required of lawyers to think that just because an activist is making my job harder, that's bad for the world. Lawyers are not the world. The courtroom is not the world. The world is on the streets. And what matters is the impact on the street. And that's the calculus that needs to happen.
Perfect, Wayne.
Can I jump in for just 1 second?
Yes, of course, of course.
I mean, I think these comments both are so important, and I hope that the panelists or the audience will jump in with thoughts on this. But I think that what both Matthew and Wayne said is really important to reflect on, because one of the things that I talk to my students about in almost every class that I teach is the insight of one of the great social historians of our time, Austin Surratt. And Austin talks a lot about the civil rights movement. And in doing so, he has this quote in one of his books where he says, the civil rights movement succeeded in spite of, and not because of, the lawyers. And he's talking about exactly what Wayne just said, that the lawyers were absolutely critical. They were critical in getting some of the big hallmark decisions in the US and some of the losses along the way and the road bumps, but that they were so scared about what was going to happen with a sit-in, or what was going to happen with a boycott, or what was going to happen if Charles Evers did this or that. And he says that like the ultimate momentum could not have happened if the lawyers, including Thurgood Marshall, it's specifically who he's talking about in some of these passages, would have been given the power that they thought they needed in order to achieve victory, right? And it's exactly because of the training that we have. And I'll just say that I've seen that increasingly in our field as animal law matures and ripens in this country to something that is more than a handful of people doing it. I see on the one hand people say, well, animal law is not important at all, which I completely disagree with, and I think that is such a radical misunderstanding of how movements work as well. But I've also seen lawyers within the movement that have become increasingly conservative. And I mean conservative in the sense of they are so terrified of a loss. Like, well, what are you going to do if you lose? What, like, we could lose in this precedent, and oh my gosh. And it's shocking to me because they have lost sight of the narrative that we're trying to convey to the public. Like, what if this case does capture the public's imagination? What if we get this in front of the court of public opinion? And what if we get a judge who does win, say that we could win and it's outlandish, but that win happens, or a jury that acquits? And I have seen animal lawyers in the last 5 years increasingly get into their tunnels in a hunch position, in sort of a crouch, and they are so terrified of taking risks when the risks are really quite low. And I think that's something that we have to think about in litigation in this movement.
Can I add just something very briefly?
Yes, of
To
course.
tout Matthew and Justin's prior work, there were a lot of lawyers, many of whom I talked to, who thought a lot of the ag litigation that Matthew and Justin did, that ultimately prevailed in the courts, was incredibly counterproductive for this reason. They were terrified about the prospect of a bad precedent being established in some federal court that would extend across the entire country. And I mean, the lesson of history taught us, well, first of all, Matthew and Justin were right. They won that case. But importantly, my view of it was they won even before they won in court, because when we got a New York Times op-ed announcing that animal torture is being covered up, right, the litigation strategy was part of a broader political strategy that frankly prevailed even before Judge Murray in Utah struck down the ag law in Utah, right? It was such an important victory just to bring that case to court. And I think this is the piece that the lawyers often don't understand. They're so caught up in the courtroom battle, they're not understanding the broader political and cultural dynamics that their litigation can be a part of. And to Justin and Matthew's credit, they did not listen to that advice. They brought the lawsuit, and they won not just in court, but in the court of public opinion.
Perfect. Well, you guys ended up touching upon some of the questions that I was going to ask. So I'm going to maybe jump to some recent controversies, because I think you have a lot to say on that. And I really want to hear first about Wayne's lawsuit against the state of California. So, which Matthew, right? Matthew, in your 2025 brief in support of Wayne, you argue that animals are someone, not something, and that they already function as limited legal persons because California law protects their own interests. If a court were to accept that reading in the necessity context, would that effectively open a backdoor to broader recognition of animal legal personhood? Or do you think it is doctrinally or perhaps strategically preferable to keep the necessity debate and the personhood debate on separate tracks? And Wayne, of course, you could jump in as well.
Wayne, before I answer that, do you want to just say a little bit about your case, and then I can sort of talk about the amicus brief that we did?
Yeah, so back in 2018, I and about 500 other activists showed up at a factory farm in Sonoma County, California, because for 3 years we had been sending reports of animal cruelty, including violations of literally the most popular ballot initiative in California history. There was this ballot initiative that was passed in 2008, got like, I think it was 8 million Californians to support it. More Californians supported this than any ballot initiative in California's history. And that's a lot of ballot initiatives. That's a lot of votes. It's actually been surpassed since then. But anyways, it was the most popular at the time. It went into effect in January 2015. What we found is like a lot of the most lauded animal agriculture suppliers were in fact blatantly violating the law. Sunrise Farms, a massive certified humane whole foods farm, had hundreds of thousands of birds in battery cages when they had said many times that they were getting rid of battery cages because of this law. In fact, the owner even said it again in court and just lied straight up in court and somehow got away with it. It's just kind of mind-boggling to me. So we decided after years of exposés, criminal cruelty reports, rescuing animals who were on the brink of death because of the horrible confinement in these facilities, we had to just go take action ourselves. And the legal theory was part of it. And knowing that we would have people like Justin Marceau and Matthew Liebman and Hadar Avaram at the University of California, Hastings, defending us and writing legal opinions in our behalf because we did have a right, in my view, to rescue these animals was a crucial part of the strategy. And maybe that's a good segue to Matthew, for Matthew to talk about his legal arguments.
Great. So yeah, unfortunately, Wayne was convicted, and uh, that's you represented yourself in that case, right, Wayne? And wanted to put on what's called the necessity defense. So in criminal law, also in civil law and tort cases, there's a right to essentially break the law or do what would otherwise be a tort or a crime if you're doing it in service of a greater good. There's some other requirements as well. And so Wayne wanted to argue that the rescue of birds was necessary because they were suffering. And the trial court held categorically that the necessity defense could never be invoked when the individual who the criminal defendant was saving is a non-human. And so the court essentially said, if it's not a human being, you can't raise the necessity defense. And so Wayne was precluded from putting on that defense at trial and was convicted. So that's currently on appeal to the California Court of Appeals. Justin's Animal Activist Defense Project is handling that appeal. Chris Carraway and Stephen Seitz, excellent lawyers, are working on that case. And I wanted to support them. One of the sort of perhaps unearned privileges of being a law professor is people often listen to what you have to say. And so I thought it was important to sort of collect the voice of law professors. So I got 24 law professors to sign on to an amicus brief, essentially arguing that the trial court erred in its categorical exclusion of the necessity defense in cases involving animals. Some great folks signed on, some of whom are on this call, some big names, including Martha Nussbaum, Larry Tribe, Michael Dorff, all kind of major animal law scholars or constitutional law scholars. And essentially what we argued is that the way, at least that the California necessity defense is phrased, is essentially what the defendant has to have done is acted to prevent a significant evil. And so our task was to show that significant evil included the suffering of non-human animals. And so we made the ethical, legal, moral case that animal suffering is ethically salient and that when animals suffer, that is a significant evil. And if someone acts to alleviate that suffering, that should fit within the necessity defense, assuming the other elements of the defense are met. So that's currently pending. And so to your question, Anna, about, we do make an argument sort of later in the brief about why animals are limited legal persons. The theory there is that they are rights holders, that they have legal rights that are conferred to them under the anti-cruelty law, even if we all know that those laws are insufficient, that they're riddled with exemptions. Nevertheless, they do provide some substantive legal protections to animals, which are properly characterized as rights, and that makes them legal persons of a sort. Now, I will say, I don't think our brief hangs on that argument. The phrasing of the California necessity defense doesn't say it has to be in defense of a person. It says to prevent a significant evil. And so whether animals are properly categorized as legal persons or some other status is beside the point, as long as their suffering is a significant evil. And what happened to the birds at the farms in Wayne's case was a significant evil, and he acted to alleviate it. So, there is this personhood question that could factor into it. I don't think it is necessary to the resolution of the question. But, sort of zooming out, I absolutely think that these questions about whether animal suffering is a significant evil that would allow one to invoke the necessity defense really does go to what our moral and ethical obligations are to animals in a much broader sense.
Perfect. Thank you. So my next question now is directed at Wayne and Justin. So in a paper you published last year with Stefan Zeitz, you argued that the defensive posture of recent voluntary prosecutions has elevated the personhood legal argument in novel ways that have received significant receptivity in trial courts. In view of this, how receptive would you say that different legal courts or juries have been to the allegation that animals are not property being stolen, but rather subjects being aided?
Do you want to take this, Justin? I mean, I could tell a funny anecdote from Sonoma County. I think judges have not been very receptive because they are establishment figures. But the funny anecdote is, so we're arguing about necessity, and Matthew's right that the actual case law doesn't require personhood to invoke the necessity defense. Unfortunately, the jury instruction does. So the jury instruction, which is written by a panel of judges, isn't actually the law, but it's like an interpretation of the law that typically judges in the United States will just use. They don't even think about the law. They just like read the jury instruction. They never deviate from it. And in California, the jury instruction, the pattern jury instruction does say it has to be an action taken on behalf of someone, on behalf of the defendant themselves or someone else. And the judge actually literally read the instruction, and then she commented in court and said, well, animals aren't someone. And after all, if we start allowing animals, what's next? Do we have to allow it for cellular matter? And when she said that, honestly, what went through my head is this is going to be so good. I almost want to lose now so we can appeal this because this is perfect. I mean, you have literally like a Twitter troll come to life in the courtroom and now in the record of a courtroom because that is just such a stupid argument. I mean, no one actually believes that. No one thinks a puppy is equivalent to cellular matter. And here we have a judge in a court of law putting on the record the dumbest argument you will find on Twitter. And I just thought this is golden. And I almost kind of want to lose so we can appeal this. But the reality is, well, I think we have seen some resistance from judges, which actually doesn't, in my view, have to do with the textual analysis, the normative analysis. It doesn't have to do anything other than judges are conservative. They're just, if you do not become a judge, I don't know what's true in Europe, but in the United States, you just don't become a judge unless you've played it safe, like your entire life. Because if you think about confirmation hearings or appointments, anyone who does anything a little bit different, you got the wrong tattoo, there's no way you're going to be a judge. Matthew's hair, sorry, Matthew, you're probably not going to be a judge. It's just too radical for judgeship in the state of California. Even in California, that's too radical. And his hair isn't even as bad as mine. Look at my hair. I mean, I got no hope. But here's the silver lining when it comes to battles in the court of law. The juries, in contrast, are very sympathetic. And the problem is, of course, you can't really make the direct argument. So in the Sonoma County case, I wasn't even allowed to say the word necessity. The judge literally instructed, and it was like, even in other contexts, if I just said, it was necessary for me to get a drink of water because I was thirsty, the prosecutor would just object and say like, oh my God, they said the word necessity. It's not allowed in this courtroom. But the jury, in a lot of these cases, including cases we won, but also cases we lost, sort of intuited the argument, even though we weren't able to make it. So the best example of this, and I think you're going to ask me about this, is the Utah case, where we're also denied the necessity defense. And we won that case. And afterwards, we talked to a lot of the jurors. I just remember one of the lead jurors, this engineer from southern Utah, very conservative guy, Lynn, who's gotten to know Justin and me pretty well. He told me afterwards, and I'm roughly paraphrasing, I just looked at this piglet and I thought, the prosecutor in this case literally is comparing this injured piglet to a dented can, but I didn't buy it. I saw this piglet hobbling around and I decided I liked her alive more than I liked her dead. And that's basically a statement of animal personhood that he has kind of implicitly come to realize in the context of this legal debate. So I guess my answer is, haven't had a lot of success with judges, although I think we're getting more success. And this appellate case and the firepower Matthew has lined up behind it is going to be very, very important. But when it comes to ordinary people in juries who are more willing to use common sense, we've had a lot of success.
Yeah, I mean, I won't add much. I think that my view is that this is an example of the kind of case where you can win by winning. I mean, you're not going to win any legal matter every time. I mean, there's just too much, noise built into the legal system. Like, to expect to do something and win every time is very hard. And so I don't think that's. But when you think about how profound the actions are in these cases and how many resources prosecutors are putting in to convict somebody like Zoe Rosenberg, they spent more time, money, and energy than this on like a multiple homicide case, right? They are definitely worried. They're not taking these cases as sort of like a joke. They are putting their full weight and force behind them because they know they are winnable. And I think that the empirical reality of how many of the cases have been won bears that out, and also just the the simple fact that they know it's a claim of conscience, right? It is ultimately the idea of putting someone in jail because their conscience compelled them to rescue an animal who was going to suffer to death. I mean, that's ultimately what is behind these, and that's not a great place for a prosecutor to be in. It's not a great place for a judge to be in. And I think time will tell, but the appellate arguments in these cases are good. I have informally mooted and shared some of the arguments with some of the leading appellate boutiques in the country. I think that they would say it's kind of a coin toss. There's legal realism that comes into play, and that gets back to Wayne's point about being afraid. If we were afraid, then we would run away from this appeal and be like, oh my gosh, there's no way we could win this. Some of the most sophisticated appellate lawyers in this country have looked at it, talked through the issues with me. And yeah, they're like, it's going to depend on the panel. It's going to depend on how they feel. As Matthew put it in an article he wrote before he was a law professor, what they had for breakfast. There's a lot of things that are going to come into play on this, but it is so far from legally frivolous. And I just want to say, that appeals and opportunities to win in cases like this is really exactly why we designed this clinic. Like we're never going to be sure that we're going to win. We're not going to pretend that we are legal scientists who have exactly the right answer. And I think the lawyers who are doing that are just becoming increasingly irrelevant and foolhardy. We're going to say we're going to fight. We're going to have a good argument. We're going to make the best case we can, and it's going to have a lot of public appeal. And when I think about why and when we set up this clinic, people that were formative in that at the time with me and talking about it, we were having conversations about how we could flip the legal momentum that was going on in favor of factory farms, how we could make the law relevant, and how we could do so in a way that was going to give sort of empowerment to people. And those conversations were with people that I really respected and had done activist defense or been on the margins for a long time with these kind of people. Amy Trakinski and Cheryl Leahy, Carter Dillard, and lots of others. They had sort of lived through some of this stuff, either with investigators or rescuers. And the whole plan was to be able to key up legal issues that were going to make a difference long term. We were never set up to say we're going to be able to guarantee everyone that we're going to win. And that was never the promise, and that's never the practice. And so again, I think that this sort of boldness is part of it's baked into a good sort of movement lawyering strategy.
Thank you, Justin. I'm going to ask one final question. So initially, this question was directed at Matthew, but I would like, of course, for Justin and Wayne to jump in as well. So Matthew, you recently wrote an opinion editorial with Kirsten Stilt about Zoe Rosenberg's case, which was mentioned here already. She's a 23-year-old activist who was prosecuted and convicted for rescuing 4 sick, abused chickens from Purdue's Petaluma Poultry Slaughterhouse. Her trial started in September this year, with her facing 5 years in prison, and she was just sentenced to serve 90 days in the Sonoma County Jail and pay over $100K in restitution. So can you tell us a bit more about this case and this sentence, please?
I was saying I will defer to Wayne. I know he's personally close with Zoe, so I think he's in a better position. Yeah, we did do an op-ed that,
But
I think
hopefully
the
not
legal
talking to her.
arguments, yeah, the legal arguments are essentially the same as what I said before, and definitely look forward to an opportunity when the appeal is ripe to submit another amicus brief in support. But I'll let Wayne share the details.
Justin, you're wrong. I'm allowed to talk to her now. My probation's done as of November 30th. So we've been texting back and forth constantly for the last week and a half, mostly just about jail. So Zoe is exactly what I think the movement needed, and I wanted to see after my conviction. So just to give you some backdrop, the animal rights movement in the mid 2000s, partly because of the power of the industry, partly because the attentional climate was very different than the way it is today. It was very hard for grassroots actors to get the word out. It was pretty much crushed by legal oppression. And I know Matthew was part of this. Some friends of Matthew and mine went to prison for quite a long period of time. And unfortunately, it actually did the damage that the industry hoped it would do. And it wasn't just factory farming activists. It was vivisection activists with the Shack campaign, My friend Adam Duran got a 6-month sentence for openly rescuing some chickens from a factory farm, and the movement was pretty effectively dismantled. And the fundamental change that I think the movement needed, and the way we engineered our work from day one, was we wanted to make sure that didn't happen. And there are two things that we really needed. One is we needed to make sure the narrative would sustain itself, that the end of the story wasn't, wah, wah, the activists in jail, let's all go home, we're all scared, right? We knew we needed to have a very powerful communications framework, narrative framework to keep carrying that story on. And social media has allowed us to do that. Back in 2005 and 2006, I don't know if that would have been possible, because the main storytellers in the nation back in that time period were the Wall Street Journal, who decried the Shack activists as extremists and terrorists. Well, nowadays, all of us can get on Twitter and TikTok and tell our own story. And it turns out 200 million people are more interested in our story than the story of the Wall Street Journal. But the other piece of this is we really did need lawyers who are bought into that, who are not just going to say, the goal is to minimize risk, let's be as conservative as possible. We needed lawyers who would say, yes, someone just went to jail, and yes, it is reasonable for you to continue trying to do this, and we will defend you, right? And I think that part of the scary thing in 2005 and 2006 wasn't just the fact that people are going to jail. It was that people felt that they had no support, even as they went to jail. I won't even go into all the gory details of what happened in the Shack campaign and in Adam Duran's prosecution. I will say they were not happy with their lawyers, and they were not happy with the legal system. And that story of how the lawyers failed them is something that pervaded through the entire grassroots. Everyone heard these stories about how much of a disaster the Shack defense was, for various reasons, again, I won't get into. And I don't even call any particular activists out. And Adam Duran's first set of lawyers, I will say Amy Cherkinsky jumped in and did a fabulous job replacing Adam's prior lawyers. But his first set of lawyers, who were not activist lawyers, not movement lawyers, did a terrible job and basically ruined his case. So I think that the key thing about Zoe's case is that it was a continuation, even in the face of legal oppression. Amy was about to object. Don't worry, I know the full story, Amy. I know you came in after the first set of lawyers, and Amy did a wonderful job, and Adam has nothing but amazing things to say about Amy, and that's because Amy's moving a line. But I think the key thing for us now in Zoe's case is what's next. What's going to happen, because this is now the second incarceration in the span of a couple of years for an activist engaged in nonviolent animal rescue work. What is going to be the next story for the animal rights movement? And that's up to us to tell collectively.
I'll just say, I'll repeat a point that we've made before. I saw in the comments somebody saying it's a great opportunity to write letters to the editor. The amicus brief that Matthew filed, amicus briefs by other scholars, including Kristen, the op-ed that Matthew and Kristen wrote. I mean, these are all forms of legal advocacy, right? This is part of what we've been trying to describe. There's a lot of nonprofit thinking that is like, there's a case and we file this case, and then when we file that case, we see the outcome, and then maybe we do some press around it. And we have a communications person, and that's litigation, and that's how we're going to achieve rights, or we're going to get better for animals. It's a whole. It takes a whole village, right? And it is not the case that it is, writing an op-ed in the LA Times is sort of extra legal. The city council might read that. The state legislature might read that. The judge's neighbor might read it. And we have often too narrow of a vision of what is legal advocacy. And I can't be more grateful for the sort of like amicus brief, op-ed, and those kind of things, because that's what we had always wanted. And when I see the suggestion of writing letters to the editor on the occasion of Zoe's sentencing, that's how the momentum keeps going, right? These cases, these legal efforts are never going to upset the entire apple cart. They can't tip it over standing alone. And so, as we said at the very beginning, we use the litigation in part to win. These are good faith cases that are colorable. Like I just said, they really are winnable. And I could talk about that in more detail. But it's also to galvanize public support, to generate public outrage about the legal failings in the system. And so we really do need people to engage and not just be like, oh, that's an interesting read. Like it requires the sort of public engagement from folks, and hopefully from the nonprofits too. It's probably going to push them to feel uncomfortable, but this is part of legal advocacy.
Brilliant. Thank you so much, Matthew, Wayne, and Justin and Wayne, I've met personally in Birmingham this year. But Matthew, I have not had the pleasure of meeting you in person yet, but it was a pleasure meeting you here. We really appreciate the time you took to just be here with us for this very interesting thought-provoking conversation. I think just the way you guys framed the strategies and how you play with the narrative, and just by changing how these stories are told, you are completely changing the outcome, I think. And I find it amazing how connected you are with reality, right? Sometimes I also come from a legal background, so it's very common. Also, I'm an academic, right? For us to remove ourselves from the world, and you're constantly trying to keep in touch with the world. So that's brilliant. And this conversation, of course, fits perfectly with the broader goal of ICARE's litigating and legislating for animal rights series, which is, of course, to deepen our understanding of the evolution of animal rights law and to strengthen our collective capacity to drive legal and social change through creative approaches such as yours. But again, thank you, Matthew and Justine, for sharing
Thank
your
you.
experience, for all your fight, right? All the work you do for animals. Maybe if you guys would like to say some last words before we end, I would like to give you this opportunity.
I mean, I'll just say thank you so much for hosting this. It's an amazing platform. I'm so glad you're doing it. I'm glad to, be a part of it. I'm happy to be a attendee in other events. It's a real gift to the meat field and the movement. Thank you, and thanks for curating such excellent questions and conversation. It was really interesting, and I learned stuff from Matthew and Wayne. So thank you.
Thank you, Wayne.
Yeah,
thanks.
I'll say, no, go ahead, Matthew.
I was just going to say thank you so much for organizing, and a real privilege to be alongside my friends and heroes, Justin and Wayne, and thank you, Anna, for moderating.
Yeah, I'll say, I mean, beyond the people on this panel who are amazing, obviously, and been so supportive of the movement of animals, I do want to shout out Kristen Still at Harvard for being just incredibly tactically brilliant, a good advisor to us, has done so much tremendous amicus work behind the scenes, and she's not often getting the headlines, but she's doing the work, and from a place of a lot of influence at Harvard Law School. And second, someone who recently is deceased, but Steve Wise. I mean, a lot of the thinking behind this came from Steve Wise, and Kristen and Steve, like Matthew and Justin, are two of a class of incredibly elite, brilliant people. I mean, they both taught at Harvard, who are willing to kind of get in the mix of the grassroots. I remember when Steve would come hang out with us in Berkeley and just go have like vegan shakes with us at Saturn Cafe in Berkeley, and he was just like one of the people. He'd just be hanging out. And partly for that reason, we came up with some of these strategies, like trying to leverage necessity to fight for the issue of personhood. This is something that was developed through conversations with Steve, and a lot of it was just from engagement. So, I mean, I think all of us should just take their cue and try and engage with each other, because part of the beauty of a movement is when all these minds come together and work together to make brilliant progress. So shout out to both those people, and especially to Steve, since he recently passed away and is one of the legends in animal law.
Definitely, that was a lovely way to finish this. And for me, it was a true honor and a pleasure just to be able to be with the three of you, just learning from you. And for the audience, we'd love for you all to stay connected with ICARE and join the next seminar in our Litigating and Legislating for Animal Rights series, which is already next year. So until then, thank you for being part of this community, striving for a more just legal future for all sentient beings. And again, thank you, Justin, Wayne, and Matthew, and congratulations on all the work you do. Thank you.
Thank you. Thank you so much. Thanks, everybody. We'll see you soon.
Thanks, everybody.